Hello, everyone. Welcome to today's NBC Impact Series event. My name is Casey Volpe, and I work with Susan G. Komen's Community Education and Outreach team. The programming for the series is envisioned as a year-long conversation with attendees, presenting new information and speakers every month. And today's topic is Settling Your Affairs. And this was requested by some of our NBC audience. So we're excited to be able to provide these resources to you today. We have two fabulous featured speakers. And they are Savia Mayman, an estate planning attorney, and Shelley Rosenfeld, director of the Cancer Legal Resource Center. So before we begin, I would like to take just a moment and thank our sponsors for supporting the 2023 NBC Impact Series. So first, thank you to AstraZeneca for being the technology sponsor for this year's event. The virtual setting means that NBC patients, no matter where they live, get to be part of this community and part of these resources. We would also like to thank our premier sponsors, GE Healthcare, and our signature sponsor, Walgreens. The series is made possible because of all of their generosity. So just a housekeeping note, while our speakers are talking, please feel free to post your questions in the Q&A feature in Zoom, and we'll get to as many as we can. Now we're excited you're joining us today, and we're excited to get started. So to start, I would like to introduce you to our moderator, Ms. Julia Hughes. Julia has been living with NBC for 7 years with vast personal involvement in breast cancer topics, skilled in communication, organization, and community support. She wants to help Komen address the needs of NBC community while ensuring diverse voices and perspectives of the NBC community are included. She's been on a roller coaster journey with her original diagnosis in February of 2015. After 5 chemos, hair loss, bone biopsy, and scans, there was a change in diagnosis to NBC in June 2015, and she was told she had 6 months to live. Now, 7 years later, she's had over 50 plus IV chemos, brain surgery, double hip surgery, and oral meds. She has fundraised for Komen Hawaii, leading a top team in dollars, participated in fundraise since 2015, and spoken at the 2019 8th Annual Susan G. Komen Pink Tie Ball, and was the More Than Pink Inspirational Award winner in Hawaii. She was also in Generations magazine in August and September of 2019, on the cover no less, and promoting awareness of breast cancer in all age groups. And just a personal note, I have the great privilege of working with Julia on some of this programming as well as other initiatives that affect the NBC community at Komen, and she is just an absolute light, joy, and just fabulous human being. So without any further ado, I'm going to hand it over to Julia.
Wow, thank you, Casey. I am honored to be here, and that was a wonderful introduction. And thank you so much. I find this topic to be especially useful. It is a tough topic to comprehend and to muster through as we deal with potential questions that come up, like end-of-life decisions and things like that of our affairs. But it's something that's useful not only for those with cancer or with a terminal illness, but also for all of us to have those unanswered questions answered for our loved ones. So when we're faced with those difficult times in the end, people will have an easier time with not only the grieving process, but to finalize those not so fun topics. Small correction, it's now been 8+ years that I've been in this journey. So I'm so honored to round another birthday and make it to 8+ years. So kudos to that. I'm very thankful for all the research and all the wonderful feedback that I do receive and get on a daily basis, and for opportunities like this to learn more information about things that I need to tend to and problem solve. So I'm also trying to finalize some last minute things and fairs. So I too will find this especially useful. Today I have the honor of moderating and also introducing our two wonderful speakers. Savia is one that I'd like to share first. Savia Mayman is an associate attorney at Mayman & Mayman LLP, a boutique estate planning and asset protection law firm in the Century City area of Los Angeles. Ms. Mayman joined the firm in 2015 and has specialized in estate planning ever since. In her practice, Ms. Mayman routinely consults with families to determine their estate planning needs and then builds custom estate plans to suit her clients' preferences. Prior to joining Mayman and Mayman, Ms. Mayman practiced family law litigation at a high conflict family law firm. Ms. Mayman's background in family law informs and enhances her approach to estate planning. Svea Mayman is a member of the State Bar of California. She earned her JD at Loyola Law School, Los Angeles, where she was a staff editor of the Loyola Law Review. She earned a BA in anthropology with minor in biology at the George Washington University, where she was a member of Phi Beta Kappa and graduated summa cum laude. Ms. Mayman was born and raised at Ketchikan, Alaska, except for 5 years of her childhood she spent living in a suburb of Jerusalem. When she is not working on estate plans, she can be found attempting to prepare slow food quickly and enjoying minor adventures with her children. And our next speaker, along with her, is Shelley Rosenfeld. Shelley Rosenfeld is the director of the Disability Rights Legal Center's Cancer Legal Resource Center, CLRC. As director, Ms. Rosenfeld provides legal services through the CLRC's National Telephone Assistance Line to people with cancer-related legal issues, counseling cancer patients, healthcare professionals, and caregivers. Ms. Rosenfeld's close to 20 legal articles have been featured in a variety of legal publications, including Prevention, Conquer, The Patient's Voice, Cancer Today, Coping with Cancer Magazine, Cancer Wellness Magazine, and Cure Magazine. In addition, Ms. Rosenfeld has spoken on the following podcasts: Money Rehab, Cure Talks, Becker's Women's Leadership, and Patients Rising. Ms. Rosenfeld participates in the Orange County Cancer Coalition, volunteers as a legislative ambassador of the American Cancer Society's Cancer Action Network, and serves as a board member of the Cancer Free Generation, the Young Professionals Division of the Tower Cancer Research Foundation. Ms. Rosenfeld was selected as a recipient of the 40 Under 40 in Cancer Award, an award to recognize the nation's most promising young oncology professionals and celebrate their contributions to improve the lives of those affected by cancer. Prior to this position, Ms. Rosenfeld worked in an in-house entertainment council at a production company and a studio, as an associate attorney at a large law firm, and as a prosecutor for misdemeanor cases in Los Angeles. Before becoming an attorney, Ms. Rosenfeld worked as a television anchor and reporter for an NBC affiliate in Arizona. She won a 2006 Edward R. Murrow Regional Award for spot news coverage and a 2005 Arizona Associated Press Award. Ms. Rosenfeld earned an LLM at UCLA Law School, a JD at UC Hastings College of the Law, a master's degree at Northwestern University, and a BA at UC Berkeley. She is a member of the State Bar of California, the State Bar of New York, and the District of Columbia Bar. We now welcome the two. Thank you so much, ladies.
Good morning. I'm Svea Mayman. I am a California attorney, so forgive me for mentioning California law sometimes because that is what I do. I really love this topic. As Julia mentioned, I come from a background in family law. I did high conflict divorce and custody litigation, and now I feel like what I'm doing is sort of the remedy to all of that, because all families need to plan for the future. All people need to plan for the future. The basic idea behind estate planning is that if you have a will, you can direct who you would like to receive your assets. If you don't have a will, then the government assumes certain things. If you're married, the government assumes that most of your property will go to your spouse. If you have children, then it will be divided between your spouse and your children. If you don't have a spouse or children, it gets divided to different relatives. And then eventually, if there's no one, it will escheat to the state, meaning that the state will get your money. So estate planning gives us the option to direct exactly how things should go. And depending on the estate planning tools that you use, you can actually keep your assets out of court completely, so that you never have to go through a court process in order for your assets to be distributed after you die. That is what we do. We give people and families the power to plan for the future, to dictate how their assets will be handed down. So without further ado, I'm going to share my screen and I'm going to get on with my slide. So this is my contact information. I work at Mayman and Mayman LLP. I'm happy to answer questions during this presentation, but I also I don't mind answering emails. If you want to email me at tmayman@maymanlaw.com. I'm obviously not going to be representing people in various parts of the country, but I'm happy to give a little bit of guidance if that makes sense. Okay, one moment, sorry. So as I just explained, the basics of estate planning are that we are helping you determine how your assets will be passed down for people with minor children who will care for your minor children. And then there are also documents that appoint people to make decisions on your behalf in the event that you become incapacitated. For more advanced estate planning, meaning generally estates over $25 million, there are other things that we can do, protecting your assets from lawsuits and creditors and different items like that. But I'm going to focus on the average American family's needs in this presentation, although these slides might have been prepared for our general audience at our firm. So we're going to ignore some of those parts. So why do I need estate planning? Peace of mind is a top reason. I prepared estate planning documents for my family when my eldest turned 1, and I felt really good about having planned for the future. We never know what's going to happen. All we can do is our best to prepare, and I always feel good about that. We control who can make business and healthcare decisions for us with the use of certain documents, and we save our beneficiaries, whoever is going to receive our stuff, from the probate process. The probate process is when the probate court manages the distribution of your assets after you die. The probate process, certainly in California, but in a lot of other places too, from what I understand, is very lengthy. It is costly because most people don't feel equipped to go through this process without an attorney. And it's just it's a really stressful headache for a grieving family to go through in order to get assets distributed. So the first thing to do when you're beginning to pursue estate planning is to inventory your assets. The first thing that we do is we send our clients out a questionnaire, and we ask for a lot of different information, but one of the most important things that we're doing is we're asking clients to inventory their assets. So that can be bank accounts, it can be real estate, different kinds of investments, businesses. People might own their own small family business. Maybe they have a business that they own with partners. It's very important to figure out exactly what assets you have that you're going to be dealing with, because that determines what kinds of estate planning tools will be necessary. The value of your estate is also important to assess. If you're approaching that $25 million mark for your household, then you require different items than a family that is not approaching that threshold. So the traditional will, I think everyone is familiar with. In a will, you dictate not only who you want your assets to go to, but you also name an executor, a person who would handle that distribution. However, even though you've appointed someone to handle that distribution for you, your assets would still be going through a probate process, which means that it would be managed by the probate court. There would be filings involved. A judge will be overseeing and approving the process of handing down your assets. And you're going to be subject to that annoying legal proceeding. Nobody likes to spend time in court, myself included. So here in California, you are not, you can get out of the probate process if your estate is worth less than $166,000. But there are certain times where even estates worth under $166,000 will still have to go through a probate. And so that is why for all of our clients, we recommend at minimum a pour over will with a family trust. I'm going to get into all of this a little bit more later. And then we have other advanced estate planning options that are recommended for certain situations. So our basic estate planning package, I'm going to mention because it includes the documents that we recommend for all families in any average situation. So the pour over will, which means that all of your assets will go into your family trust. The certificate of trust is an accompaniment to the family trust. It's supposed to be the shorter portable document that you can bring to financial institutions, although sometimes they want to see your full family trust anyway. The family trust, I will discuss more later, but it keeps everything out of probate court completely, which is a tremendous advantage. And that's why, especially here in California, where I practice, we recommend it for all of our clients. Along with our estate package, we include transferring one property into the trust. The trust should be holding all assets, but we include as part of our package transferring a property with the idea that your home should go directly into your trust, and we want to make sure that that happens right away. And then we include the durable power of attorney, which allows you to appoint someone to manage your business affairs in the event that you become incapacitated. The durable power of attorney for healthcare and the advanced care directive, those are both healthcare documents appointing an agent and also specifying your wishes that medical professionals can read and reference in the event that there is not an agent available to direct them and you are incapacitated. But we'll get a little bit more into those documents, and then that will conclude my presentation. I'm trying to keep it very brief here to leave time for questions. And also, I know that this is very boring, but it's important stuff. So I'm happy to be here, and I want to talk about it, and I will try to be less boring if possible. So I guess I'll throw a few terms at you. A grantor is the person who is making the trust, putting assets into the trust. We'll talk more about the trust later, but the trust is the big empowering document that we recommend to everyone in California. I know it's necessary in other states, although not entirely necessary in all other states, from what I understand. The beneficiary or the grantee is a person who receives gifts under the trust. So it could be your children, it could be your friends, it could be your children and your friends, and a charity. It could be just a charity. You are the master of your destiny with your family trust. The trustee is the person that you appoint, or it could be more than one person, to manage and distribute your assets under your trust. This is in place of the probate court getting involved, which is wonderful. And then a personal representative is basically like a trustee, but that's a person who is appointed under your will. Or if you don't have a will, or you don't appoint someone in your will to manage your assets, then it's a person appointed by the court. We don't want a personal representative because we never want the court to be involved. But that is what the person would be called if the court process was necessary to initiate. And California is a community property state. We're not alone in that, but not everyone agrees with us in that regard either. Community property and separate property are important things to identify when you're doing your inventory of your assets, because those will also affect how your distribution might happen and practical elements of how we would set it up for you, or how any attorney would set it up for you. So the pour over will is a will that in the event that for some reason, some of your assets don't end up in your trust, a pour over will puts those assets into your trust after you die, so that there shouldn't be much court involvement, limited to no court involvement, even in the event that something is left out of your will, left out of your family trust. The pour over will works together with the family trust in order to ensure that all of your assets end up out of the reach of the probate court judge and solidly with your appointed agent who you trust to take care of your distribution for you. So the revocable trust, again, is saving you from the lengthy probate process where you'll have to pay an attorney to go through that lengthy court proceeding where you will have multiple filings, and then the judge will eventually determine how or approve how your assets are passed down. Even if you've explicitly written it out, it can't happen until the judge specifically approves distributing your assets. I handled one case where there was one account that was accidentally left out of the family trust. It wasn't even through the fault of the family. The financial institution had titled the account improperly. And as a result, the account wasn't included in the family trust and it had to go through probate. And I handled that. It took close to 2 years to get this one account through the probate process, which was very frustrating for the family. So another issue with probate is your assets are tied up until the conclusion of the probate process, meaning that you don't have free use of the assets, even if they're very clearly going to a certain beneficiary. The court needs to release them before the beneficiary actually receives them. And also probate filings are public record. So all of the information about your assets will be available for anyone who wants to look it up through the court system. So your revocable trust works together with a pour over will to allow the person you appoint, your trusted agent, to distribute the assets according to your wishes without the court getting involved, and it will keep the process private for you. And I should note that during your lifetime, the assets that you have, even though they're titled in the name of the trust, they remain completely under your control in a family trust. So you're not relinquishing any kind of control. You're just creating a legal vessel to hold your assets for the purpose of the state not being responsible for distributing them after you die. You're giving the state the clear to say, I have taken care of this. I have appointed my agent. You don't need to be involved. This is all me. I'm creating my own private world of how my assets will be distributed. So as I mentioned, we recommend that certainly every person who owns a home in California should have a family trust, because it just makes the process of transfer much easier after you die. We do have a relatively new transfer on death deed available in California. I understand that's available in other states as well. In California, the transfer on death deed it has some limited applications, and the process of using it can also be confusing and difficult for a lot of people. And so the transfer on death deed has not become a favorite here, and the family trust is still really the best way to manage transferring your assets, but especially transferring your real estate. So the durable power of attorney document is the document that you use to name an appointed agent to handle business decisions for you in the event that you are unable to do so. The durable power of attorney is great in that it's not a conservatorship. So you have someone appointed to handle business for you if you can't do it, but in the event that you recover, you immediately are able to handle your own business again. You don't have to go through any kind of filing or process. you can just jump right back in. So here's an example. Batman holds the durable power of attorney for Superman. Superman executes the document so that Batman can legally handle Superman's affairs in the event that Superman runs into some kryptonite. And then Batman, with his attorney powers, can conduct business and access money on behalf of Superman. And then once Superman is back in his cape, Batman will seamlessly stop acting on Superman's behalf, and Superman is back in control. There's no need to go through long efforts of proving competency again. The durable power of attorney for healthcare is similar. It just manages the healthcare aspects rather than the business aspects. So if Batman is holding the durable power of attorney for healthcare for Superman, Batman will make healthcare decisions during a time that Superman is incapacitated based on the wishes that Superman has expressed to him, and also generally a brief expression of wishes in the document, but that's going to be hard to encompass everything that you would want in a document. So it's nice to be able to appoint someone you know and trust to do that for you. And then again, once Superman recovers, he can just start making his own decisions. Again, Batman will stop acting for him seamlessly. There's no need to go through a process. The Advanced Care Directive is another healthcare document in which you are directing medical professionals as to a general idea of your wishes so that they can try to make the best decision in the event that you are incapacitated and they are not able to reach your appointed agent. They will follow your wishes as expressed in this document to try to give care according to your wishes in the best manner possible. So those are the documents that we routinely prepare as part of our regular package that all families should have. I want to spend a couple of minutes talking about digital asset planning. This is more of an emerging area in law because digital assets have more recently become very important for a lot of people. People do all of their banking online. People might even have social media that they're very attached to or consider to be valuable. There are so many things that are done online now, and the legal industry is struggling to keep up with this. There is a constant enduring struggle between the tech industry that wishes to reassure everyone of their privacy online and the legal industry wanting to ensure that an appointed trusted agent, like the holder of a durable power of attorney, or a trustee who you've appointed in your trust, or an executor under your will, is able to handle digital assets in any way that would be necessary or appropriate for you. So this is a conflict that different states have handled in different ways. Many states have passed uniform rules about how a representative can access digital assets. So most states have passed rules that state an appointed fiduciary, meaning an executor of a will, a trustee of a trust, a holder of a durable power of attorney to make business decisions, or a conservator who's appointed by the court, will be able to access most of your digital assets. But if you have made any specific election within a program, such as appointing someone for a Facebook legacy account, or there's a Google succession plan that you can opt into, those are two that a lot of people might have encountered. If you make an election like that within a program, that will always be controlling over what you might have written in your estate planning documents. And additionally, these uniform laws that many states have adopted do not allow you to access, they do not allow a representative to access the content of your emails or text messages or any social media. So the California rules that we've adopted here are similar to those uniform rules, except they have made it even stricter. They only include access for trustees of trusts or executors of wills. So if you have someone acting as your agent and your durable power of attorney for business decisions because you have become incapacitated, they will not be allowed to access any of your digital assets. And the same thing for a conservator. they would potentially have to go through a laborious process to ask for access from the various online platforms, and they could be denied. So these are just interesting things to think about. And it is an emerging area, and I hope that we will get more clarity over time. But this is probably something everyone should think about. The basic idea, the summary is that if you make any election through an online platform as to who would have access in the event that you become unavailable, don't sign on for 6 months, whatever the setting might be, that will control over any document that you have. But in all of our documents, for anyone who is interested, we now include consent to allow your appointed agents to access all of your digital assets. And we specifically include social media as well for people who would like their agents to be able to access all of these items. We make it explicit in as many ways as possible, because we are fighting the fight to empower our appointed agents through the legal process. And in most cases, that should be fine. The tech industry wants to see that there has been explicit consent before they would potentially violate someone's privacy. And life insurance is something that many people also use to close the gap and to make it easier for families in the event of a death. For many people, life insurance might not be available, but that is another useful tool that we use sometimes and that clients might be interested in. And that concludes my presentation.
Great, thanks, Svea. Hopefully everyone can hear me. I'm going to now try to share my screen and just do a brief overview of where I work, what we do, and kind of tying it in a little bit to resources after Svea's fantastic presentation. Thank you so much, Svea. So let me just adjust this for my slides. And I just want to say that I know that the topic of advanced planning can be challenging. And I think that that's an important point to acknowledge. However, I will say that no one lives forever, even Betty White. And that I think it's actually the way to think about it is perhaps that it is empowering to have someone's wishes live beyond their years. So even though it can be, in my opinion, quite intimidating for anyone to think about estate planning or advanced planning, I think it's just so helpful to find information just like Svea shared that can help you understand the terms, and then to start to think about, okay, well, even if someone doesn't have that much, sometimes they think that they don't need a will or a trust, but that's not the case. Whatever someone has, it's a good idea to decide where you want it to go and to whom you want it to go. So I think it can be incredibly helpful to really learn about this, and it's really an opportunity just to think ahead and to feel empowered that no matter what, your wishes are upheld. So let's talk a little bit about the Cancer Legal Resource Center where I work. So we provide free legal resources to people affected by cancer nationwide on a variety of topics. We provide information to someone affected by cancer. It could also be an oncologist, a patient navigator, a caregiver. Everything we do is confidential, and our resources are free regardless of income. We have a presentation series of national webinars, and we actually have one on advanced planning. So that's coming up November 9th, if you'd like to learn more. We also have one coming up in October, health insurance and open enrollment. It's called Know Your Rights, and it's supported by generous grant from CGen. So if you're interested in the other topics that you see on your screen, we have them on the Cancer Legal Resource Center YouTube page, which you can access through the Cancer Legal Resource Center website. So you don't have to worry about it. And even if you haven't seen the other webinars, they're not cumulative. They're not based on one another. So you can jump in at any time and watch any of the webinars in any order that you wish. So what are cancer-related legal issues? Now, advanced planning actually is one of them, of course, but I think it's just worth touching upon before we go a little bit more into the details that there are a variety of topics, and hopefully after this presentation, if there's other areas that you want to learn more about to help make sure that you know your rights, whether you're currently facing a situation or you might have a concern about a situation or you might just want to learn more, those are just some of the topics that we help with. So even though, Svea and I are lawyers, we do research, we don't represent anyone. Svea's law firm does represent people, but we do not. We help people nationwide. So, and I'm not licensed in every state, and we're a small team. So we just actually provide free resources. We have an educational model. So we also have, if someone is a lawyer, they can volunteer to be a part of our professional panel, specializing in the topics that you saw before in one of those. And when someone contacts us, if they need more information about an area and we have a lawyer in their state that practices in that area, that lawyer agrees to talk to that person with cancer or affected by cancer for free for half an hour. And there's no obligation on either side. It's just actually understanding from someone who practices in that area. So just for you to know. Also, we have something that we just started this year. It's called a legal self-help clinic. And basically, so what we do, you call us or you fill an online intake. However, what's on your screen is actually, we actually go to a comprehensive cancer center or another location and are there with a bunch of our handouts and someone from our staff to help answer questions. We are not able to do all the research for someone in that moment, but we can do an intake, but at least talk you through some important points related to your issue. So, and that's for free. So if you're interested in this, talk to your doctor or medical team to see if we can come to your preferred location. So far, we've been at UCLA's Brain Tumor Conference. We've been at City of Hope Comprehensive Cancer Center. That's in the Southern California area, and UC Irvine's Chow Family Comprehensive Cancer Center in Orange County. So we've been at a few locations, but we're always open to being more. And then finally, the Cancer Legal Resource Center, we have a free patient legal handbook that talks about a lot of the legal issues, including advanced planning. Although I think Svea's presentation was so good, I actually want to rewatch it at some future point just to learn more and more. But we talk about a whole bunch of issues. It is free. It's available in English and Spanish on our website, but we also will mail it. We have bulk orders that we mail for free. You don't even have to pay for shipping. We send it to doctors' offices and other locations too. So you can definitely access it for free or order a copy for free. So I'm just really gonna go over, I'm almost at the end of my presentation, but I just wanted to touch upon kind of a CLRC tip related to advanced planning. And it's, this is an opportunity to talk about advanced planning, but no matter what someone's health is, I think Svea would agree with that. Her clients are not only those affected by a cancer diagnosis, they're all sorts of backgrounds, ages, demographics, no matter what someone's health, it's a good idea to, document, any of your preferences related to, estate planning, your property or healthcare decisions. So it's, if possible, to think about that ahead of time as much as possible. And even if you think that family or friends know what you want, if it's not in writing, it might not be sufficient and could leave your friends and family in a difficult situation of trying to figure out what to do. You are the only one who knows your true beliefs and desires, down to what you want to have happen if you cannot care for yourself. This is true when it comes to decisions about healthcare, as well as decisions about your property. And then finally, we talked just a brief overview, a review of what Svea talked about, planning for someone's property versus their health. And so that's kind of a helpful way to think about it. And, there's a resource that can be really helpful, and I'll show that on the next screen. There's an organization called Compassion and Choices. And there's also an organization called Caring Connections. They have advanced healthcare directive forms for every state. So we're the Cancer Legal Resource Center. So as you can see, we have some resources as well. and 5 Wishes. So you can check out their website. It's relatively affordable to kind of express your own wishes, at least to start the conversation going. Someone often doesn't think about their pet, who they might want to care for their pet, for example. Now you might have someone in mind, but it turns out you didn't realize that they're allergic to, you might have, a pet and they're allergic to that pet. So it's good to think about these types of issues in advance, and not, I would say, try not to think of it in a negative way, because like I said, no one lives forever. I wish that was the case. But one way to kind of help us live beyond our years is to really express what you want to happen in the future. That's, I think, a really helpful and constructive and empowering way to think about it. So thanks so much, everyone, for your time. I'm going to stop sharing my slides, and we may have some questions, I suppose. Hopefully for Tzvia, she's a lot more knowledgeable.
Thank you, Svea and Shelley. It was, there's so much wonderful information. One thing, Shelley, they asked that you put up your contact information that you shared at the beginning of your presentation. And we do have a couple questions for either one of you. I don't know who would want to answer. There's so much wonderful information here. The first question is, what is the document most people don't think about filling out or having in place when planning for end of life?
I guess I can take this one. This is a tough question to answer because everybody has a unique situation and everybody thinks differently. But if I had to say one, I would probably say the durable power of attorney for business decision, because people, I think when you go to the doctor, they talk about the advanced healthcare directives, and people know, I need a will, I want to write down who should get my stuff when I die. But the durable power of attorney for business decisions is very useful, because in the event that you're incapacitated temporarily, it allows your trusted appointed agent to sign for you and to manage your business. So that's very important. And I think a lot of people might not consider that.
Thank you. Excellent. Another question from the audience. What happens with any credit card debt left at one's passing if the only person on the account is the deceased? And will that amount owed come out of the assets of the deceased, or does the debt just go away to some extent with the deceased?
I can take that one too. Part of the probate process, when the court handles the disposition of assets, is to settle all of the debts. So that happens first before any assets can go to beneficiaries. And the family trust also, it will settle those debts before any funds can be distributed to beneficiaries. There are certain situations where that might not be the case, but in the overwhelming number of situations, all debts should be settled before assets are distributed.
Thank you. Excellent. We have another question. What should my caregiver know about the end of life documents I have?
This is another difficult one, because I think that we run into a lot of practical elements of, I have my documents, but now what do I do with them? So what we recommend to our clients is you should have some very direct and open conversations with whoever your trusted people are to talk to them about your wishes. And then we always, after we prepare and have our clients sign documents, we actually upload the executed signed documents onto a jump drive, and we give them to the clients, because that makes it easy to share them. They can just email copies to whoever their trusted people are. And of course, the original executed copies should be kept in a safe place that you can access in your home. Some people might put them in safe deposit boxes. Some people say, no, a safe deposit box is too hard to access. I want it in this place. None of these are exactly simple or easy answers. But the best thing you can do, I think, is just to have frank conversations with the people you trust and give them copies of those documents. If you don't mind, Julia, I saw I think a little bit of frustration on, I was glimpsing at the chat while I was off. And I saw someone was saying that it's very expensive to use an attorney for estate planning. And I completely understand that. I'm very lucky that I was able to prepare my documents myself. I know that not everyone can do that, although everyone can kind of do that, because if you have a simple estate, if you don't have a complicated business situation, maybe if you own a home, but you otherwise don't have a lot of complicated assets, and depending on the state, in California, it's really annoying to pass down a home through anything other than a family trust, although you can do it. In other states, from what I understand, it's not as much of a burden. You really can fill out a simple form will online. You can fill out healthcare documents, simple forms online, and those should be effective for simple asset situations. Those really should do the trick. And additionally, because the courts really don't want to be making decisions for you and imposing the state's default assumptions on your behalf, in California, and I believe in most jurisdictions, we provide for something called a holographic will, which means if you take a piece of paper and in your own handwriting, you write down, I want my stuff to go to this person, and you put a date and you sign it, that is effective as a will in court. That will be used for probate by a judge. And the important thing there is that it is in your handwriting, so that the idea is it can be authenticated as being your actual wishes. The date is important because imagine someone has executed a bunch of different wills. The most recent one is always the one that controls. So the date is very important. So yes, I understand. Nobody wants to pay a lawyer. I totally get it. I sympathize. I don't want to pay lawyers either. And I think that for simple asset situations, I hope that people would be able to get away with just doing some basic estate planning on their own.
Thank you, Sylvia. It's funny because that was the very comment I was going to pose in sharing, and you had jumped. We were like telepathically connected there, which funny enough, it does fall into the next question, and I believe you've answered it here. What do you think about online wills or other medical documents, and do they hold up in court? And did you have anything you'd like to add in regards to that?
No, I think that for people with simple asset situations who don't have complicated assets, complicated business situations, I think that on the whole, they should be okay. You're going to be going through that probate process, but in some states that's less painful than it is in this state. And I think that can really be fine for some situations.
Excellent. And then there was a follow-up question, where can I get a checklist or other form to help ensure I've thought of everything?
So I don't have any kind of comprehensive checklist. I don't know if this is something that the CLRC maybe has like some magical checklist. What we always do is we tell the clients, make a really good list of your assets, figure out, what do I have? Because once you have a good list of what you have, then it makes it much easier to see, okay, this is what I have to do in order to dispose of them properly. Certainly you can make a list of beneficiaries as well. For some people, they want to make a list of charities that they would like to give to. Usually that's a much easier list. But I guess my list of the ordinary documents that we recommend to everyone is also a good list.
Wonderful. Thank you so much. I believe we need to wrap up our question time. Thank you, both of you, for sharing your expertise. And I believe all the contact information is out there for others to brainstorm and add their additional questions. So with that, I'd like to pass it back over to Casey. Thank you.
Thank you so much, Julia, and to our fabulous legal minds that were kind enough to spend an hour with us here today. That was a wealth of amazing information. I know I learned quite a bit and now feel like I have a lot of work to do myself. So thank you for that guidance and the insight. I definitely feel more equipped to have some conversations moving forward. So again, just a very special thank you to Ms. Mayman and Ms. Rosenfeld and our moderator, Julia Hughes. I'm so appreciative of your time and your energy and your insights. So today's session was recorded and will be posted to our landing page soon. So you can rewatch this session, view previous sessions on other topics, whatever you may have missed or find valuable is always there for, free access when you have the time. So please help us spread the word about this important content, friends, family, healthcare professionals, anyone you think that might be interested. And once again, we want to acknowledge our sponsors. Without their generosity, these resources and these topics wouldn't be able to be covered. So a special thank you to AstraZeneca for being the technology sponsor for this year's series, our premier sponsor, GE Healthcare, and last but not least, our signature sponsor, Walgreens. So thank you everyone for attending today. Last request for today, I promise, please complete the survey. It is in the chat feature. It really helps provide insight on what topics we should tackle next, how the event went, whether it be logistically or presentation wise. I personally look at them and it does help inform my program planning. So I really appreciate any time you give to me to provide that insight and feedback. So our next MBC Impact Series event will be October 13th, and that topic will be research and health equity. And we look forward to having you along and enjoying the conversation. You can register now for that event on our landing page as well. So thank you again for today, everyone. Thanks to everyone who made this event possible, and stay safe and stay connected.